Hey everybody, this is Jason with Triad InfoSec. Welcome back to another one of our webinars. I'm here with my friend Brad, who we're going to talk about all things legal when it comes to cyber risk. So before we dive into it, just for those that don't know me, I'm the founder and CEO of Triad InfoSec. We are a cybersecurity company that focuses on risk management, cyber leadership, compliance, and we literally look at cyber risk at the organizational level. We help senior leaders realize that cyber risk is not just a function of IT. There's a legal piece to it. That's why we're here today. There's a big component for HR departments to consider when it comes to cyber risk. About me, I'll kick it over to my friend Brad. Let him introduce himself.
Yeah, thank you, Jason. My name is Brad Chambers. I'm a shareholder with the Houston office of Baker Donaldson. Baker Donaldson is a national law firm, approximately 750 lawyers nationwide from Houston up into the Northeast into New Jersey as of a couple of weeks ago. I chair one of our litigation practice groups, and we have a team that involves data risk, data breaches, and the litigation that follows from that. I'm glad to visit with you, Jason, about any questions you may have and some insights from the legal side of the fence, so to speak.
Yes, absolutely. Well, thanks. We can get into it. To start with, as I mentioned in the introduction, work with a lot of organizations. The legal side of things, just like the HR side of things, kind of out of sight, out of mind. I've worked with companies recently to uncover, what the contractual requirements are. When it comes to cybersecurity and the posture, that their vendors expect them to uphold. And so we work with solutions that can, pull those contractual requirements out, because the last thing that we want our clients to do is to operate in a fashion where they're maybe already in breach of contract, maybe because they're not carrying the right limits of insurance. Maybe they're not set up in a way that could satisfy the breach notification time window. So little things like that. So from your side, when it comes to contractual requirements and potential breach of contracts and what that fallout looks like, can you tell us a little bit about that?
Sure. Yeah. And I think this falls into at least two buckets here, and maybe three. One is your compliance before you have an issue. Is making sure that you have a wholesale review of, are you in compliance before you have an issue, a data breach issue. It is really important. Are we doing things the right way contractually? Are we doing things that need to be done? Because that in and of itself can cause business issues that come up, and it could result in a lawsuit and those sorts of things. And it also makes for larger exposure on the liability side. Secondly, I think the second bucket that a lot of people think about this is when you have a data breach issue, or you have a cyber attack, is a triage response, is sending out notices, stopping the issues, jumping through all the hoops of the immediate situation that you have. And then the third bucket is the litigation side that may fall out from that. And what a lot of companies see is they put their triage emergency response team as their litigation team, and not necessarily those two things do not have to go together, nor should they, because those are two different skill sets, two different time frames you're working on, two different issues you're working on. Compliance, stopping the bleeding, making sure that everything is squared away, and then if you have ramifications from that, that is a slower response and a more thoughtful, at sometimes strategic response of how you handle that litigation down the road. And so our firm handles all three aspects of that, but not every team that responds to the data breach is the right team to handle the litigation down the road.
Yeah, no, that makes great sense. Yeah, and with us, helping our clients be proactive, looking at the contractual requirements to make sure they're operating within those and they can meet, any of, any of the limits that come up. But another big thing that we do, and you mentioned it, is around incident response. And I've gotten questions from several clients as we are going through and talking about the incident response plan and just kind of brainstorming who needs to be part of the incident response team. What does that look like? And then we start preparing for a tabletop exercise to kind of walk through some mock scenarios. And a lot of times, they ask me, well, we have outside counsel. Do they need to be part of the tabletop, or do they need to be part of the plan in general? So I guess talk to us a little bit about uh, what organizations should do when it comes to incident response planning. How much should they get a firm like yours involved in that process?
I, and generally speaking, I would get a firm involved in incident response, if nothing else, to protect the privilege and to have candid conversations about what has gone on that don't become discoverable down the road. And so by engaging counsel, you're limiting some honest and candid feedback internally, and that communication should be protected in the anticipation of litigation, because you have counsel involved and you're seeking legal advice and legal counsel on those issues. And without that, those issues become far more discoverable.
Gotcha.
And you're basically making a roadmap for plaintiff lawyers coming behind you.
Yeah. And not being an attorney, that's why I tell clients that they definitely need to talk to one to understand what that fallout could be. Because the incident, depending on the severity, if you've got data leakage and it's customer, information, they find out, yes, there's probably going to be some lawsuits being filed, or even before that happens, I guess making that decision on uh, how do you do the breach notifications? How do you let people know that this has happened? And I always suggest people that's really one of the key things you want to talk to your attorney about, because because contractually, back to that, you may have to let them know. And when you do, again, if it's bad enough, there could be ramifications, as you mentioned, and just need to protect yourself accordingly, is what I tell people.
Yeah, and the whole sphere of people that have been affected by a data breach or had some sensitive data breached versus those that are actually damaged by that breach is a much smaller sphere, and that have a concrete injury. And without getting into too much legal speak here, the United States Supreme Court, in a case that came out a couple of years ago, really narrowed who has standing to bring these cases in federal court, by stating that you have to have a concrete injury. Just the disclosure of the information is not enough to have damages. Okay. You have to say that caused me an injury down the road because someone used my name and went out and applied credit, and now I'm exposed to these things, or whatever the situation is. This exposed information, proprietary information, where we're going to drill what the reserve values are here. It goes through a number of permutations here, but you have to have a concrete injury. It's not just the disclosure of the information in and of itself, or the violation of a regulatory schematic or a law that causes damages that can be sued upon. And so you have to have a concrete injury. And so that's why the incident response, the data notification, is so important.
Yeah.
But then making sure that the people that, if you get a class action filed against you, these people are actually damaged by this, because it's the numerator of how many people that are really damaged really runs the driver for any damage figures that are coming up. And making sure that you have a very tight pen and really sharp pencil on, okay, these people were the actual damage, and narrowing that class down as much as possible is really how you handle the litigation side of the world.
Awesome, man. That is great information. Yeah, definitely taking some mental notes to go back to some of our clients and kind of explain this for sure. Well, how do organizations protect themselves? I know we talked about incident response, but kind of on the contractual side, is there things that they should have in their contracts, when they're, having clients sign, or vendors, and especially, third party risk, vendor due diligence is a huge part of our world, and the contracts are a big piece of that. And what should be in these contracts? How can you really protect yourself?
one of the best ways is just have an indemnification, that data breach indemnification, that if a data breach happens on people that you're sending information to, those people owe you indemnification and you're an additional insured under their data security privacy policies. And that takes some diligence on every company size to make sure they get those policies, they get that additional insured certificate, they have that indemnification language within their master service agreements or master agreements, and that takes some review for time. There is another school of thought that you may want to put arbitration clauses in all these, which would take these matters out of the courthouse and put it into a private arbitration. There's some good and bad that comes from arbitration, and that probably goes beyond the scope of our conversation today, but it takes it out of the public viewpoint. If the public disclosure of the breach and the continuing case is really a brand exposure issue, you want to make sure that you're minimizing. And so those are some strategic items that people ought to sit down and companies ought to sit down and think about what they're doing. The other thing that, and it goes through all sorts of things, is what are you doing as an organization to train your people to not have this situation where they are vulnerable to an attack? And I know we as a law firm, we get tired of it sometimes, but we go through testing after testing after testing after, here's some fake emails, make sure that you're not clicking on stuff. And, let me take that full circle. When you start showing that through a jury and says, look, this is the organizational efforts that we have done to protect this. There is the backdoor stuff, the technical side that, I'm not qualified to really talk about. But it's impressive to a jury. Hey, we've done all these steps. We have done this with our own people to make sure that they're not providing open portals here. Mm-hmm. And this is the testing. And here are the compliance documents of everything that we've done. Well, you're going to take all the Madden people out of a jury. You're going to say, okay, this was a mistake. This happened. Somebody, came in through left field and really got after you here in a way that, you couldn't anticipate. I think that is very protective of most companies, but showing that compliance over years, quarters, as a continuing effort is really important to minimize liability. And we've seen that in not just data breach litigation, but a continuing course of litigation. Is what is this company doing to protect the public from these issues?
Yeah, and I've seen some of that. We're the company that makes sure people are getting trained with the email phishing simulations, and we help build the compliance program and make sure everyone knows what the organizational policies and procedures are, and of course all the technical controls are in place, because I've seen a lot of that, especially in healthcare, where PHI, patient health information, was breached, and HHS and OCR would come out, do their investigation, and if you can show them that, look, we're doing everything the HIPAA security rule says we should do, and nothing is bulletproof, right? If human error is human error, something's going to slide by. That's just the way it is. And I guess if you can exercise that due care and saying, hey, we've done and we followed the rules, we're trying to do everything that we can to prevent this, and unfortunately something happened, then you can get off a little bit easier. I don't know if you can get off scot-free, but it definitely helps, to your point.
Yeah, absolutely. I wholeheartedly agree with your position on that. And just, continuing diligence and continuing mindfulness of that this is an issue, that there are, and I'm just going to be blunt about it, there's criminals out there that are trying to hack into this information at all sorts of levels, at every organization, whether it be a law firm, whether it be a bank, whether it be an oil and gas company. It's across the board. And all of our work, my children ask me what I do for work. I was like, I type stuff into a computer at the base level. I'm thinking and I'm typing, and that's mostly what we're doing. And so once that information gets in there, that people are, wanting to address that for a number of issues and a number of manners.
Yeah, I'm glad you said that, because I say that all the time. But I think, coming from an attorney, it may have a different impact, because these cyber criminals, they're full-fledged organizations now. Exploitation is their business model, and they're making a ton of money doing it. So they're going to continue to do it, and they don't discriminate on size, industry. Yeah, some data may be worth a little bit more than others, but if they can get their hands on it and they know that it's important to you, then the chances of them, getting the money to return the data, possibly, we are dealing with criminals, as you said, so there's always that. Uh, yeah, it's really important for people to understand. I've worked a few breaches over the past couple of months where small business, unregulated industry, didn't think it was going to happen to them, and it did. Yeah,
Sure.
and so it's a real problem out there. And someone said it best, and I always laugh as I hadn't heard this until a few months ago. They're like, you're not too small to get hacked. You're just too small to make the news. Yeah.
That's, that's
So I
true.
thought that's really good. So I use that a lot, but it's very true.
And,
and so the best thing.
and what, go ahead. I'm sorry, please.
Oh no, I was just gonna say. I mean, the best thing you can do is just operate with that mindset that something will happen, and just you need to be proactive and protect yourself accordingly.
Yeah, and do the best you can. We we received a report about our firm and how many times hacks were attempted in a year, and it was amazing how
Yeah,
many times that we were probed and luckily thwarted and been able to avoid those issues. But it's an incredible diligence and some really good thinking people on making sure that our data protection and data security is secure as it can be in this day and time.
yeah. No, it does, and reports like that are scary, and that's what people don't see because traditionally they have the right solutions in place, to block those attempts or push them off into a black hole, whatever the case may be. And I tell people, I was like, if you really want to know how fast you could get hacked, just open up a remote access solution into your network and watch the logs. It will fill up almost immediately. So the threats are out there, they're real. Protecting ourselves, but I wanted to go back to one thing on the contractual side that I thought about as I was dealing with this one client. Um, is the contractual requirements when it comes to cybersecurity, are those negotiable? I mean, because I've read some that seem a little extreme to say, okay,
Sure.
if you're going to do business with us, these are the things that we want to have access to or we expect from you. Like one was in the event of a breach, if that breach affected their data, then they wanted access to your computer systems to do their own forensics. And to
Hmm.
me, that seems a little bit, I can understand where they're coming from, but it seems like it would muddy the water when it
Yeah.
comes to incident response and who's doing the forensics. And, the insurance companies have a whole process to whether they're going to make a claim decision. And if you've got, your customer over here coming in and doing stuff on your network while you're trying to figure it out yourself, it seems a bit much.
Yeah, and I will tell you they range from across the board, and a lot of it depends on just who's got the bargaining power.
Mm,
A larger corporation, a top tier client is going to have a lot more leverage on some of the smaller vendors or equal sized vendors. And so we've seen that the agreements run the gamut of where those things that we can come in and audit your systems, we can come in
yep.
and audit in the case of a data breach, all your systems versus just we want you to make sure you take care of the security of the data that we send you. So I mean it runs the gamut across the board, and a lot of it depends from a legal perspective is who we're representing. If we've got somebody that's got the bargaining power, then we're going to push the issue. If we are trying to put our toe in the door, then we're probably going to accept a little bit more risk and realize that that's the price for doing business. And I know that's not a clear cut answer, but that's the reality of where we are in today's society.
Yeah, no, I mean that makes sense. If you want to do business with us, this is what it's going to take. So I
Sure.
guess you as the potential client have to make that decision. Is this worth
Hmm.
it? Can I meet these? Because you obviously never want to find yourself in breach of contract. Obviously
Hmm.
that can get messy in itself. Yeah, but all that's been great information.
One of the other things I think that a lot of people don't look at when they're addressing their data risk, cyber risk issues is the not just the service disruption they can have to their customers and loss of data, but the secondary ramification that has within an organization. It takes an enormous amount of energy away. It erodes a tremendous amount of trust, but it also internally degrades a lot of trust in the people where that breach may have occurred. And, it slows down the efficiency of a lot of companies. And I don't think a lot of businesses look at that. They look at the financial consequences, they look at the legal risk, but it's the intangible cost, the employee morale, the third party relations, the stifling of innovation at some level that needs to be addressed and needs to be thought about as the totality of circumstances.
Yeah, I mean that's a great point. Yeah, the morale. Think about that angle. That's interesting, but it's absolutely true. I do
Mm-hmm.
talk a lot about the reputational damage. That a breach. Because it affects you in the present, but it could affect you in the long run. Because if that breach was reported and people, they're like, oh, I don't want to do business with somebody that's been hacked in the past. I don't want that, to happen to my data. So they're going to move on and find a competitor that maybe hasn't. And it just really boils down to being proactive and reducing the likelihood, and then hopefully reducing the impact as well, when something does come through, because again, nothing's bulletproof.
For
Um,
sure.
so another question that I've had from customers, and again, not being a lawyer, I don't want to really speak too much to it, but I have seen organizations that had an active breach. They filed an insurance claim, and the insurance carrier brings their own legal counsel into the situation. We'll call it. So why do they do that? What's their role? So if I'm an organization and I either have internal counsel or my own outside counsel, and they're part of my incident response process, but then the insurance carrier wants to bring another, team of attorneys to the table for their side, what does that look like?
Yeah, and many times when an insurance policy is triggered, whether it be in a liability circumstance such as a data breach, in that circumstance, whether it be in a large scale car wreck or anything, the insurance company has two basic duties. There's a duty to indemnify, which is to cover those costs, but there's also a duty to defend that comes under a policy, and that comes under a homeowner's policy, an auto policy, a general commercial liability policy, a cyber risk policy. And so when they have that duty to defend, they are controlling the defense of any lawsuits that come out, and they're anticipating litigation. So they're bringing in lawyers at that point to defend the ultimate exposure of the policy that they've sold you. So if you have a $10 million policy, they're out there protecting and trying to keep those damages within those policy limits or minimized to an absolute minimum. And part of that policy, although policies differ, have a cost of defense attribute to them, which they have to engage counsel and pay for it. And so all these insurance companies have panels of counsel, right? They select the counsel to go out and defend you. A company that's had a data breach has got ability at some level to fight back on that and say, no, we want our lawyers in, that they are involved in the incident response, or they know our systems and we would like this. And that becomes a discussion in a lot of situations. But when you go out and buy a policy, you can have a writer out there that has right of counsel, that you get to select counsel. And so it's a negotiated term when you're buying a policy. Most people don't even think about it. There's some very good panel counsel, there's some very bad panel counsel, and there's everybody in between. And so, saying that ubiquitously that, everybody the insurance company brings in is great or terrible is just not accurate. Some of them really know what they're doing and are quite capable. Some of them don't. And it's on a case by case basis. But that is what the obligation under an insurance policy typically is not only a duty to indemnify, but a duty to defend you, the insured, against liability claims.
Wow, very interesting. Now, this has all been great stuff. I mean, we touched on a lot. Yeah. So, I mean, if you're out there listening to this, to recap, you as a company, check your master service agreements, your contracts, check the contracts that you're signing, the people you're doing business with, that you can, stand up to those requirements. Get attorneys involved in your insurance planning, get your attorneys involved in the incident response process. All these things have a major impact on your overall, ability to recover from incidents, your ability to, you know, stand up against any potential lawsuits. There's a lot of different ways those can come at you, so you want to be, proactive. And I think this has been great. Any final thoughts, Brad? And just for the
My final
listeners.
advice to any company or organization out there is have an overall cyber strategy, from prevention to incident response to litigation to the insurance aspect. Sit down and take some time to say, hey, this is how we're going to handle things that may happen in the future, and have that already in place. Don't try to build that on the fly once something happens. Have it in place. This is what we're going to do. The people need to be notified. This is going to be our breach counsel. This is our team that if something happens, we're our incident response team. This is the way we're going to go about it, and have an overall strategy ready to go in what is becoming not a remote contingency these days.
Yeah, no, that's some of the best advice I've heard, and it is so very true. I preach the same thing. You know, as an organization, you have to have a program, you have to have a strategy, even if it's not mandated by a three-letter agency. The guys out there that are in these non-regulated industries, they need the same proactive planning and strategy. Because they're their target as well. So,
Yeah,
but no, all great stuff, Brad. I really appreciate the time
you bet.
today, and this has been a pleasure, and hopefully we can do this again sometime.
Absolutely. Glad to help. Good to talk to you.
Yes,
And best of
sir.
luck to everybody out there.
Thank you.